passed since the law was enacted, how successful is law in India, and what are the changes required. This also, ma'am, I think is directly not related to enforcement of arbitral awards, but I will try to imbibe the topic with the question. And as far as the enforcement of arbitral awards is concerned, as we know that since 1996, our part two has remained the same. So therefore, we must conclude with that from 1996 to 2020, that is 34 years, the part two of arbitration has survived the evolution of law more, because as I was submitting, because the New York Convention has been able to champion the cause which it has set to achieve. And as far as the other part, that is part one of the Arbitration and Conciliation Act is concerned, I think most of it has been addressed in the 2015 amendment, which was, I think, in my opinion, was a commendable uh, amendment to the act. But however, I do not know whether the 2019 amendment, by bringing in international institutionalized arbitration, whether that will be helpful or not, or whether it will again be a breeding ground for corruption, which we come to see quite often in our country. And as far as the other parts of the arbitration law is concerned, I think because the arbitration law has the focus of the trading community, the ICCA and the IFCI and ICA, and therefore I think it is constantly under scrutiny. And since the business community, as we can understand, since the business community is involved, uh, the financial stakes as far as the country as well as the business community is concerned are quite high, and therefore it is constantly under the looking glass, and that is why we have been able to achieve the two amendments of 2015 and 2019 to streamline the procedure. I hope that, ma'am, it answers your query. uh, um, there are I do not see any significant questions in this regard. uh, Very well. So I'll hand over the floor to either Ashutosh or Orko, who can take over from me.
Orkoda will take over from here. Thank you, Shishada.
Thank you
Orko,
so much. Thank you, everyone, for being so patiently listening to the paper. Thanks a lot. I appreciate your the paper. Thanks a lot. I appreciate your
Shishana, there is another question in the chat box. There is another question in the chat box. What would happen if arbitral award is not legal in any of the contracting parties' country?
if the award is not legal. I think that I have already answered, and the answer can be found in Article 5 of the first schedule, where it has been mentioned, right? Where it has been mentioned, right?
In the chat box, which says the New York Convention is mostly accepted, is something there which should be changed or amended in this recent era. Would you deliver your views about that?
Yes, as you can understand, the New York Convention was there. So you can understand the New York Convention was there by, and differences. Changes are required to be made to streamline the process. But as of now, and that is also being discussed by the trading community, and that is also being discussed by the trading community and the arbitration authorities, international arbitration authorities. In fact, as I was saying, Mr. Nariman himself was the president of the authority, and they were also discussing it, I think, uh, uh, in this last uh, conference which was being held. So we have half a century old, and this convention has become half a century old. And with the growing need, and as you can understand, the situation we are going through, and as our all the sovereign states, not only India, we are trying to bring the economy together, and uh, relying more on domestic production and domestic economy rather than FDI and FII and international trading. Therefore, the conventions have to meet that requirement also in the post-COVID situation, because law as evolving as it is one thing, and in this post-pandemic situation is completely another thing, and that has to be addressed by the entire legal community. And the last is from Ms. Shengupto, which says that what happens to arbitration clause if the main contract ends. Now, Ms. Shengupto, the thing is that, yeah, thank you, Kia. Most welcome. Yeah. So, Ms. Shengupto, the arbitration clause is an agreement by itself. So, even if the main contract ends, the clause remains valid. Like, for example, a contract agreement by itself says void, but it contains an arbitration agreement. That arbitration agreement will survive, and one of the parties whose rights have been breached, they can ask for an arbitration to get his damages, and the arbitration agreement will survive. All right, Orko, you can take over.
Well, before we let you go, we have Dr. Ochina Kundu, the senior most teacher of our college. I would request her to make a delivery of vote of thanks to you for attending the webinar and addressing us.
There you
Ochina ma'am, if you could please take over.
Well, it's my pleasure. Can you hear me? Am I audible?
Yes, ma'am.
Yes, ma'am, you are.
Okay. Well, it's my pleasure to thank Shishanu, who had been once upon a time my student, but now, of course, the roles have reversed, and it was a great learning experience, Shishanu. In fact, we read it academically, we read the law, but you are practicing in the court, so naturally, we get to learn a lot more from you. Your
Thank you, ma'am.
address was really enthralling, and I personally learnt a lot from there. Well, thank you
So much,
once again on behalf of the college. I'm proud to have such students, Shishonna. May God bless you. You are already shining. You are a
Thank you
shining
so much.
star in the high court sky. I wish that you reach greater heights. Thank you so much.
Yes. Thank you so much, ma'am.
Well, with that, we come to an end of the first session of today. Mr. Brett Lovett would be shortly joining us. He has already intimated me within a period of like 2-3 minutes he will be joining us. I would request everybody to please be on hold for just 1 or 2 minutes. Mr. Lovett would be joining us, and then we would be moving on with the second half of the session. I thank Sri Shonoda for attending and addressing us once again, and I believe that we could have successfully done gone on with the three segments of this international webinar, and we are in the valedictory segment. And please bear with us for 2-3 minutes. Mr. Brett Lovett would be joining in soon.
Organizers, are you there? Organizers?
Yes.
Yes, Vishwananda.
Yes, I just forgot only one thing. I had promised at the beginning that I will share the notes with the audience so that they get all the citations and the details from which I had made the presentation. I just forgot about that. I'll just give you the link and you can share it when you want to. Okay.
Yes,
Sure.
yes. Thank you. Ashutosh, please take a note of that.
I have given it on my screen. Kindly take a note and you can uh, then share it with anyone who wants it.
Okay, thank you.
You have got it? Can I stop sharing?
1 second, Shishant, 1 second. Thank you. Got it.
Can I stop sharing?
Shishana, I would request you to kindly keep your camera on once. I request. Yes, yes. You
You can stop sharing, Shishant.
Ashutosh, once the screenshot is taken, please let us know, and please let us also know that once Mr. Lavid enters, he's supposed to enter anytime.
In the screenshot, he hasn't entered yet. I will let you know.
Okay.
Hello, Orkota, Mr. Lovett is here. Orkota, can you hear me?
Yes, yes, yes. But I can't see you. If you would please respond.
Marka, this is Brett.
Yeah. It is good evening here, but I made you wake up at 7 a.m. I am extremely sorry for that.
That's no problem. It's my pleasure to be here.
Yes. Before we go in, Brett, we have the Junior Standing Council of our state, Mr. Shishonna Bandopadhyay, with us. He was taking the session before you. If you would like to share a word with Mr. Bandopadhyay.
Thank you. Thank you.
I hope you have a good session as well. I had a very patient audience and a very good session along with the Q&A. I hope you have a good session as well.
Excellent. I do my best.
Thank you so much.
So before we start with the session, let me introduce you to Mr. Brett Lovett. Mr. Brett Lovett currently serves as the headmaster of the Institute for Conflict Management and the University for Distance Learning, which both serves as a certification, recertification, continuing educational and professional development providers. Mr. Lovett is recognized as a dispute resolution specialist. His background is in mediation and conflict resolution. having attended the Status Institute for Dispute Resolution at the University School of Law, Loyola Law School, and the United States Institute of Peace. He is certified trainer for the Nationality Recognized Conflict Management Certifying Authority, NACM, conducting conflict management training programs for certification both domestically and internationally. Mr. Lovett has traveled to India extensively, working closely with retired members of the Supreme Court, most notably his good friend and former chairman of the Press Council of India, Honorable Chu. Mr. Lovett has visited most of the high courts throughout India, engaging and assisting members of the judiciary in to help alleviate the mass legal caseload of the country, but also to provide guidance to the personal lucrative profitability that become an advocate and dispute resolution specialist holds for those who pursue this avenue for the case of the resolution of disputes. I would like to further bring forward a point before the audience that this particular program which we are having, the international webinar on the Golden Jubilee, is also one of the contributions of Mr. Lovett, because it was his idea, I would say, because I and Mr. Lovett, we were having a discussion over a forum where we came to an idea of this global partnership, and then I invited he accepted to speak that why Indian advocates must embrace alternative dispute resolution as the best option to attain personal wealth status and client satisfaction as well. Something which we need to hear after the informative session with regard to the technicalities and legalities as addressed by Mr. Bandyopadhyay. Over to you, Brett.
I appreciate that introduction, Marga. Thank you. And I'm going to speak slowly, a little bit more deliberately, so that I know sometimes if you talk too fast over the internet, it can get lost, or the connection can break down. But if there's a problem, please let me know with my pace. I made a few notes. I've done these programs before, and I'm going to do my best to just bring out a few key points that I think are important from my personal observation and from my personal experience while being in India and engaging with not only Indian advocates in the judiciary, but also on occasion with their clients as well. So let me begin by saying this: the success of a nation, and I'm sure, and I hope that you would agree with this, the success of a nation depends greatly on the effectiveness of its judiciary. And unfortunately, as we've seen in years past or in the years leading up to now, in India, we see a judiciary that is stressed, right? Stressed with pending cases. This is from personal observation. When I was there, the few times I've been there and engaging with litigants and clients, litigants often feel lost when they have to face rigid, I would say costly, time-consuming procedures of law. So as a result, and as I know all of you are aware, years ago, the Indian legislature introduced the best mechanism for resolving most, not all, but most disputes. And that mechanism, as you are all familiar with, is known as ADR, or Alternative Dispute Resolution. Okay, so here's my question. If this were the critical state of affairs in India, in the pending cases, if this were a true accounting of the situation facing the Indian judiciary prior to COVID-19, in this worldwide pandemic that has afflicted the entire planet, if this were true before, then my question is, how much more so is this post-COVID-19 world, or this post-COVID-19 reality, where the openness of the public courtroom has literally gone away and will be away for the foreseeable future? How much more so do we need to employ ADR mechanisms now in a post-COVID-19 world as opposed to the pre-COVID-19 world? If it was needed then, and we all agree that it was needed then, how much more so is it needed now because of the world that we live in now? None of us know for a certainty what's going to happen. We live in a world of uncertainty, for sure. I'd like to address, again, from personal observation, and I made this years ago while following through the land of India and visiting the various high courts, and it was a cause of concern for me then. And what I observed is that many advocates were against a number of advocates. Maybe that's a better way to say it. A number of advocates were against ADR or mediation, at least some of the ones that I talked to. And their thinking was that the introduction of ADR, especially mediation, was going to be an attack, you might say, or a violation of their right to livelihood, and it would render them somewhat useless in the legal process. And I'd like to be perfectly clear at this point, since I'm talking to such a large group. If you are of this way of thinking, or if you are of this mind, you could not be more wrong. That statement could not be further from the truth. And it's just a mere myth. The reality is, friends, the truth is exactly the opposite. A client needs their advocate at each and every step of the ADR process. A client needs their advocate at each and every step of the mediation process. So the role of an advocate is crucial. Your role is crucial in this process. And so I wanted to dispel any myths that you've heard or that you may even carry in your own mind about this not being a good way for you to make a living. Nothing could be further from the truth. I'd like to talk a little bit about the role of the advocate before mediation, during mediation, and after mediation. And these are there's much more involved here, but I just want to highlight a couple points. I'd like to start with the role of the advocate before mediation. And as I talked to different advocates, my inquiry showed me that the majority of parties to a dispute are usually completely unaware that they even have this avenue open to them. So this is a crucial part in the advocate's process, is that you are the one that has to make the parties aware that they have this avenue to pursue, what the benefits of pursuing this avenue are. If they don't hear it from you, they're probably unaware of it and likely won't know of it at all. So the crucial role of the advocate starts right at the very beginning in you assessing whether or not your client is even aware of this process. And if they are, if it's something that they would be interested in pursuing. It's a perfect opportunity to support both the process and your client. What about the role of the advocate during mediation? Well, mediator can only, as you well know, the mediator can only make up or help generate options, right? They can't order, they can't force, they can merely suggest at best, or help generate options, as I mentioned. But this is again, a crucial part of where the advocate comes in. The advocate's needed. As an advocate, you become a vigilant champion of the process, essentially, okay? And you guide your client in the best possible manner. So you have a role of educating beforehand. If you do engage in the process, then your role becomes a champion both for the process and for your client at the same time, guiding them along. And if they have you there, they're going to feel more comfortable about the decisions that they may or may not agree to. So again, a crucial part that you as the advocate plays in this process. What about after the mediation? Let's say the mediation is concluded. an agreement is reached. Advocates play a significant role after the mediation as well. The client may need continued support. So it isn't necessarily that an agreement is made and everybody goes their way. The client may need continued support. They may need, the client is, the advocate, is in the best position to ensure that the agreement is being followed, that the parameters are being worked with as set out in the agreement. So again, the advocate's crucial role is that they help ensure the adherence to an established agreement, and that cannot be underestimated. Advocates should keep this in mind. Even though the mediation process involves referral judges, mediators, and the parties themselves, the advocate plays a significant role in the whole process. And I would add the word crucial role in the whole process. I think some of that information you may already know. If not, then I continue to support and urge you to look into this avenue for potential clients that you may have. What are the advantages? What are the advantages? We talked about the advantages for the client. What are the advantages for the advocate? And that's kind of what I based the theme of this discussion on, which was the ability to enrich yourself or make a living, a livelihood, a formidable income, able to achieve publicity, good publicity or status in society, and really peace of mind because you brought forth satisfaction not only to your client, but as a result to yourself. Those, to me, are the three driving factors that drive all of us in this industry, or drive all of us into what we do. Now, you may hold others, but those are the three that I see as most prominent. Just to speak on income. So what are the advantages? These three advantages. Well, the advocate themselves decides the fees to be charged. So you as the advocate decide yourself the fees to be charged for mediation process, for the consultation, for example, for the preparation of briefs to be shared, et cetera, et cetera. You determine those fees. Obviously, the more prowess you have, the more publicity you have, the more what the more you are known, and the more cases you bring to settlement, the more interest people are going to have in using you as their advocate. And obviously that will directly impact, right? I don't know how else to say it. That will directly impact your income for the better. Let me put it to you this way. You could feasibly conclude 30 to 40 cases for mediation in the time it might take you to see one case through all the way in the traditional court system. So let me say that again. You might be able to conclude 30 to 40 mediation or ADR cases in the same amount of time it would take you probably just to see one case through in the traditional Indian court system. Now you tell me which avenue is more likely to bring in income or enrich your income. I think the answer is obvious. But I don't think it was always understood in that context. Hopefully that's changing on the part of advocates, as I can see the fact that your attendance to hear and to the subject of ADR proves to me that's changing as far as advocates are concerned. But you can make a substantial income practicing this avenue of dispute resolution. Let's talk a little bit about publicity or your status, the status in society. With each case you bring to settlement, you enrich not just your income, you enrich your public status. You enrich your standing in the community. You enrich your standing in society. So if you conclude 30, to borrow the example from above as far as the income, let's say you conclude 30 to 40 mediations or disputes, or you bring them to settlement in the time that it would take you to see one case through the traditional court system, well, then you are achieving 30 to 40 times the status, right? 30 to 40 times the publicity, 30 to 40 times the good standing in your community, in society will have been achieved. So again, I think the numbers speak for themselves. If you're going to enrich yourself income-wise, why not take the avenue that allows you to do 30 to 40 times what you could income-wise, to do 30 to 40 times what you could to your status in society. To me, that would make a lot of sense for you as the advocate and for the clients that you represent. And lastly, what about satisfaction, client satisfaction? What about peace of mind? And there's a saying that says anything can be bought, but not so with peace of mind. So the feeling that your client saw or got a measure of justice is the fulfillment of your role to society. So it brings you satisfaction because you are fulfilling your role as an advocate when you help guide along a dispute to resolution. You are fulfilling your role to society. Your role is to figure out the best way to bring about a measure of justice for your client, to give them peace of mind, and to do it in a fashion that is economical as well as not time restrictive or not time consuming. Many of you are aware of the directive principle of state policy, Article 39A of the Indian Constitution. It says that justice shall not be denied to any person on the basis of an inability, whether physical or monetarily. Okay, so justice shall not be denied to anybody based on an inability, either physical or monetarily. So you fulfill this directive through positive mediation experiences. You also fulfill the role towards the judiciary, and that you save the judiciary time and you lessen its burdens. So all of that falls under client satisfaction and peace of mind. You are not only serving your own interests, but you are serving the interests of your client in the best way, and you are serving the interests of the judiciary in the best way. And all of that brings about an inner satisfaction that cannot be purchased with money. So this is how you, through mediation or ADR, achieve wealth, status, and client satisfaction. Friends, I'd like to, at this point, make some additional comments in regards specifically to the situation around the world at this time, which is the COVID-19 has created a shift really in the way that we live and in the way that we work. Even in the way many of us are still trying to find our way through that. What will the world look like, in 2 months? What will the world look like tomorrow? How will this affect me? This is again a crucial part that you as an advocate plays in your community and with your clients. So you can be an educator in the community. You can be a force in your community. You can be an educator with your clients. And I know that you, in your area, your specific, really taking that seriously, and I commend all of that. So virtual mediation, online mediation, virtual ADR, that's really what we need to start looking at right now to deal with access to justice. We can't just come to a standstill. If we do, we're going to implode on ourselves. And we were already, if you are, that's fantastic. What about the other high courts? What about other advocates? What about other areas of India? What about other Indian we all need to get on the same page because we don't know where this is going. So what can we do now? That's the question we ask ourselves. What can we do? What can I do to just can't come to a standstill? Well, I suggest that virtual or online mediation is something that we need to take seriously and act seriously now. Is it perfect? No, it's not perfect. We still want to make sure that we have areas of confidentiality covered, so to speak. That has a lot to do with the type of platform we're using. But other than that, we can move forward and not just stand still by using this type of avenue or mechanism for justice. Not only is online mediation or virtual mediation resistant, it's resistant to COVID-19, it actually can thrive on it. So think about that. It's not just a Band-Aid. We could actually thrive because of COVID-19. Mediation is an idea whose time has come, and that time is now, friends. So don't let advocates steeped in antiquated adversarial ways, so to speak, deter you or your client from pursuing this avenue of justice that is open to you, to your clients, to all of us. The great advantage of online or virtual mediation is that it's convenient, it's cost effective, and it's an efficient use of time. Okay. Clients don't have to, or the parties involved don't have to bear all the costs. They don't have to wait long hours. They don't have to undergo adjournment after adjournment, and they don't have to make multiple visits. Remember Article 39A of the Indian Constitution. And they have the right to speedy justice, quick justice, and they have the right to because of that. So again, online or virtual mediation, ADR is allowing us to fulfill Article 39A of the Indian Constitution and to do it very well. Mediation can provide clients with a cocoon, more of a cocoon, you might say, of safety, especially with cases where can run high, such as in matrimonial cases or family business disputes. And what about when parties are located in different countries? I mean, how did we deal with that before? That was usually a barrier, a difficult barrier to overcome. No more. Never before we had the ability now that is present through online or virtual mediation to convene parties to a case, because we can do it virtually no matter where they are. So these are all advantages, and very solid advantages to this type of pursuit or access of justice for, as well as, again, the peace of mind, the enrichment economically to yourself, and the enrichment of your status as a practitioner in society. So I appreciated the time that your faculty members, that your associates with the law college there have put into this arrangement. I hope that good information has been shared with you. I hope that there's information that you can move forward with that will help you in your decision making. And I hope that some of the things that I've mentioned here today, you can think about. We're looking for long-standing relationships. We're looking for partners. And what I mean by that is partners of mind, people that share the same ideas. And we can help one another move forward. COVID-19, perhaps you've seen this. Some people, some countries are just in a standstill because they don't know what to do. That doesn't have to be the case for us. We can move forward. Are we going to move forward perfectly? No. But we do have mechanisms at our disposal that were there before that we need to take advantage of now all the more so. So I hope that was really what I wanted to convey is there are many people standing still. There are, perhaps there are other law colleges in India that are trying to figure out what they should do and how they're going to help their faculty and their advocates to question to you here is, are you going to be a follower? Are you going to wait and see what others do? Are you going to take the lead in Calcutta? Are you going to take the lead? Are you going to stand out to that? So where somebody says, hey, aren't you an advocate that went to such and such law college, and they're really the preeminent force behind ADR and mediation. I mean, don't you want to be that law college? Don't you want to be associated? Don't you want to be an advocate associated with that type of leadership? So, again, you're either going to be a follower or you're going to be a leader. In my proposal, I'm offering my hand of friendship and my hand of working together with you so that we can be leaders in this area, that we can set an example for others to follow. Because in my heart, I believe this is the best way forward, and I hope you feel the same. So again, I appreciate the time that you took out to listen here. Hopefully I brought out some points that were new to you. And at this point, Arka, I'd like to turn it back over to you. I don't know if there's any questions that you have or that anybody might have. I don't know. I can't promise I have the answer, but I will either write it down and find out, or we will find another means to do this. But that is pretty much what I wanted to share with your group this day. So again, I appreciate the opportunity to do this.
Mr. Nag, over to you.
Well, I'm sorry, I missed that. Was that a question to me?
No, he requested me to take over so that I can read out a few questions for you.
Okay.
Which has been in the chat box.
Okay.
So the first thing is, Anindita Haja says, Mr. Lovett, Indian lawyers are always emphasizing on litigation process instead of mediation arbitration, as consultation fees are expensive and time consuming in traditional legal litigation procedures. What is your opinion on this?
My opinion is, as I highlighted earlier, Arka, that's exactly the case. That's what I found when I was in India. The litigants, the fees were high. It was a difficult process to go through, and that was before COVID-19. Cases are drawn out. It's difficult. Then you had other advocates that weren't of like mind. They didn't want to pursue ADR, so you had to deal with that. You had to deal with that concept too. Again, I highlight what I highlighted in my speech, is that you have to be an advocate for the process, not just an advocate for your client. You have to be an advocate for the process. If you do that and you work towards that goal, and you can move cases into dispute resolution, then you're going to see that you're going to have an opportunity to make fees. You're going to have an opportunity to get your client justice quicker than you would in the traditional way. And you're going to have client satisfaction, but you're going to have personal advocate satisfaction too. You're doing your job for the judiciary. That's really the best way I can answer it. So I agree. I concur with the comment. You have to be an advocate for the process, is how I would answer that.
Well, there is another question, Brett, for you. That is, in India, the recognized mediator can only get his fees as fixed by the respective high court rules when effective mediation in a case takes place. He does not get respective fees for respective sittings. Like the point which is is that in India, the mediation fees and everything is fixed by the judiciary. So what exactly is the condition there in the United States? Like whether it is the mediator to decide, or there is any rule or law, or the judiciary fixes it?
No, it is for the mediator and the parties to decide in the United States. Let me be clear. I am aware that the judiciary fixes the fees once a case. Now, this is an important point. Once a case is established, once the dispute is established legally, but are you aware that you have the opportunity to enter into mediation privately before the case becomes formally introduced into the system? At that point, you have an Indian advocate has the ability to establish the fees that they want before the case becomes formal. So you do have that opportunity. You do have both prior to the case. But once the case is established, I understand, yes, that the judiciary in India sets the fees, but not prior to it. So the advocate has much leeway prior to set the fees and to guide that process to settlement without it becoming a formal case.
Yesterday, Brett, there was a question to Dr. Walter Wright. The question was that what is your take on the aspect of mediation or arbitration or conciliation so far as the criminal justice system is concerned?
Okay, Arka, can you repeat that? So far as and then I didn't hear, so far as the something system is concerned.
Am I audible? Then I would repeat.
Can you, just repeat. Arka, can you repeat the question?
Yes, am I audible? Am I audible?
Yeah, you're fine. I just didn't catch one word.
Yes, and the question is that what is your take so far as the mediation or arbitration or conciliation matters are there with regard to the criminal justice system?
Oh, okay. With regards to the criminal justice system in India?
Yes. In India, we do not have a mediation process that far, but what about the United States, and what is your take so far as the entire concept is there? Like, so far as the criminal justice system and the mediation comes into being?
Yeah, I am a huge proponent of, if it was available, obviously in the civil system, mediation is available across the board. It is an option across the board. In the criminal system, not so much. Matter of fact, not at all. I mean, it is to an extent, I guess we call it negotiation, right? There are negotiations that take place, but there's no formal mediation in the criminal process. However, I would be a proponent for that, because there are types of quote unquote criminal cases that could really benefit from dispute resolution, from mediation. They're the lesser infractions, you might call them. I think the smaller, lesser criminal infractions could really benefit from the ADR mechanism. Not so much more serious criminal matters, but the lesser criminal matters. Yes, I'm a proponent for that. Does it exist? Not really, but there is talk about it. We do, and again, in this post-COVID-19 world, what are we going to do? Cases are backing up everywhere, and something needs to be done. So I apologize. I don't know if I answered the question, but does it exist here? Not really, but it should on a lower level for smaller offenses. Obviously, in the civil world, it exists across the board, and it's pretty well used. Mediation is well used here in civil matters.
Well, another question is from Mr. Dhot, that whether in United States there is any codified law so far as mediation is there.
Yes, the simple answer is yes. If they could be, I would be kind of guessing at what the student may be asking about there. If they could clarify a little bit more what they're asking. But the simple answer to that question is yes, there is codified law in regards to mediation.
Yes, I do not find I'm sure the person who put the question, Shambhulal Dhar, he has heard it. If he has any specific thing to ask Mr. Lovett, then he can put it in the chat box. I would read it out for him. Well, let's not. Well, there is another question, Brett, that is how one can make a bridge in between mediation and judicial activism.
Yeah, wow. Let me just tell you, that's a great question. I commend whoever asked that question. That's a thinker, and that's a great question. It's not easily answered, and I don't think there's any one specific route between that and judicial activism. I think that largely depends on who you are, who your influences are, who you have access to in the community. If you have access to decision makers, so quote unquote, in the community, people that have a say-so in the community, people that share some sort of authority, then I think the bridge that you would build to activism would be different than a person's bridge who doesn't really have those contacts. So that's a difficult question to answer, but it's a great question to ask. You need to look at who you are, where you're at, and who you have who's in your realm, in your life, in your community, and you start engaging them in conversation. You start engaging them in thought. And if they're decision makers, that's how you start building a bridge to activism.
Well, thank you, Brett, for the lovely session and answering the questions. I am certain that we would be working together and we will be sharing more partnership as we have discussed in other fields as well, in more professional and more codified field, if I say that. So I am looking forward to it. And before I hand over the mic to Neil Vasu, the General Secretary of the college, I would request you to put forth a bit of your one or two words for the webinar and for our Golden Jubilee. And I would also request you to kindly hold back because we are going to end the session with the national anthem of the United States of America.
First and foremost, thank you very much, Mr. Shishano Bandyopadhyay and Mr. Brett Lovett for such a great session. And indeed, all the participants in the webinar was very much benefited from such a great session. As the moderator, Mr. Orko Kumar Nag said at the inception of this second day of this Golden Jubilee webinar, that last night it was almost 1,000 viewers. If we sum up the YouTube, the Facebook, as well as the Google Meet, and many messages I have received last night that many of the participants like this seminar like anything, and it was a great a gesture indeed from the part of the participants. I thank each and every participant, each and every speaker, and obviously this was the initiation of our Golden Jubilee celebration, which will be a year-long celebration, and we are planning to do it more digitally due to this pandemic situation that arose due to the COVID-19. We are trying to make this digital platform a place where we can unite not only throughout India but globally. And what Mr. Brett Lovett said today in respect of the global perspective regarding arbitration and mediation was of immense importance. And again, I thank Mr. Shishano Bandyopadhyay and Mr. Brett Lovett for such a great session, and we will looking forward for such a great other programs which will organize through this digital platform. So thank you very much on behalf of Jogesh Chandra Chaudhary Law College. I thank each and every participant, speaker, and all the guests who had contributed to this, and of course the team who worked throughout the 24 hours in making this event a great success. So thank you, all of you.
Thank you so much, Neil. Thank you so much.
But it was a nice gesture of putting a namaste in return of the thanks put forth. Like, I would request Ashutosh to kindly play the national anthem of the United States of America, as we have Mr. Brett Lovett with us, so that we can end the session on a global note. I would request everyone to rise. Ashutosh, kindly unmute it and restart the national anthem. It is not audible. Please unmute it. Good night, ladies and gentlemen. Have a great day ahead. Fred, it was early morning. I made you wake. Thank you once again. Thank you all. Thank you all. And goodbye.
Thank you, Arka.